My name is Leis and I'm a Senior Associate here at Clarke Hemmerling Lawyers. Today we're going to be talking about pre-action procedures in family law property matters. The family law rules require parties to take certain steps before starting a case in the Court for Property Division. These steps are called pre-action procedures and are designed to help parties resolve their dispute without litigation in the court, or at least narrow down the issues. Step 1. If you are considering going to court, you must first invite the other party to participate in dispute resolution. Dispute resolution is also known as mediation or settlement conference. You must also give them a copy of the Federal Circuit Court and Family Court of Australia brochure about these pre-action procedures. Step 2. The parties are to agree on an appropriate dispute resolution service and make a genuine attempt to reach agreement by participating in the dispute resolution process. Step 3. A written notice to the other party of an intention to file court proceedings is to be sent if 1. The other party refused or failed to participate in dispute resolution, 2. No dispute resolution service is available or deemed appropriate, or 3. No agreement is reached at the dispute resolution. If no agreement is reached, then the notice must attach the pre-action procedure brochure and also set out A. the issues in dispute, B. the orders sought if a case in court is started, and C. a time frame for the other person to respond that's no less than 14 days from the date of the letter. If the other person does not respond within the time specified, then you are not obliged to do anything further, and you can file a case in the Federal Circuit and Family Court for Property Division. Step 4 of the process is that if you have received a letter, which is a notice of intention, you must reply in writing within the time frame and state whether or not the offer is accepted. If you do not accept the offer, then you must reply in writing setting out 1. the issues in dispute, 2. the orders you will seek if a case is started, 3. your genuine counter-offer to resolve the issues, and 4. a time frame for the other party to respond that's at least 14 days after the date of your letter. Step 5 in the process is that if both parties have made a genuine attempt to settle after participating in a dispute resolution, but an agreement is still not achieved, then they can file their case in the Court for Property Orders. One of the major impediments to reaching agreement is when parties do not properly disclose documentary evidence that's relevant to the issues in dispute. Parties involved in property negotiations have an ongoing obligation to provide full and frank disclosure of all the documents they can access that are relevant to their financial circumstances and to the issues that may be raised. This should be done early so as to not hold up negotiations. At Clarke Hemmerling Lawyers, we can provide clear advice for your particular circumstances and advise you with respect to your property negotiations.